Shaughnessy versus Eidsmo features a lazy house seller, a couple who eventually lost their patience, and the ever-popular statute of frauds. Mark Shaughnessy and his wife leased a house from Bernt Eidsmo for a year. According to the Shaughnessy's, Eidsmo orally agreed that the Shaughnessy's would have the option to purchase the property at the end of the lease term, and that the rent paid for the first year would be credited to the purchase price. Eidsmo also agreed to sell the Shaughnessy's a stove, payable in monthly installments. After the year was up, the Shaughnessy's told Eidsmo they wanted to exercise their option to buy the house. They asked him several times to deliver a contract of deed. Each time, Eidsmo said he didn't have time to have a contract drafted, but his word was good, and they shouldn't worry. The Shaughnessy's continued to pay installments on the property and the stove. Eventually, the Shaughnessy's sued Eidsmo for specific performance of the conveyance. The trial court found that the Shaughnessy's had a vendee's interest in the property and that they were entitled to a contract for deed from Eidsmo. The court denied Eidsmo's request for a new trial. Eidsmo appealed to the Minnesota Supreme Court. He argued that the oral agreements fell within the statute of frauds.